It's finally happening. The ATF's Pistol Brace Rule is officially collapsing nationwide. The Trump DOJ just dropped one of the biggest appeals in the entire fight, which means the nationwide block against the brace rule stays in place. But here's the twist. While one case looks completely settled, another one's being stalled because of the government shutdown. So what's really going on? Is this the permanent end of the Pistol Brace Rule, or just another pause before the next round? Let's break it down. When the ATF released its so-called final rule on pistol braces, it threw millions of gun owners into confusion overnight. The agency claimed that pistols equipped with stabilizing braces should now be classified as short-barreled rifles under the National Firearms Act. That single move flipped years of accepted guidance on its head. Suddenly, law-abiding Americans who'd legally bought or built these firearms were told they had to register, modify, or destroy them, or risk becoming felons. And none of this came from Congress. The ATF simply reinterpreted existing law and imposed a brand new regulation without a single vote being cast. That's why lawsuits exploded almost immediately. Gun rights groups, manufacturers like SB Tactical, and 25 states lined up to challenge the rule. They argued the ATF had gone far beyond its authority, rewriting law instead of enforcing it, and violating the Administrative Procedure Act in the process. Over the past year, those challenges have moved through the courts with mixed results. Preliminary injunctions here, temporary stays there. But one case in particular became the centerpiece, Mock versus Garland out of Texas. Judge Reed O'Connor struck down the rule completely, calling it unlawful and procedurally invalid. The Biden DOJ appealed that ruling to the Fifth Circuit. Now the game has changed. The Trump Department of Justice has decided to drop that appeal entirely, effectively agreeing that the lower court decision stands and that the pistol brace rule remains vacated nationwide. That's not just a technical win. It's a massive signal about where this administration stands on the ATF's power to rewrite gun law through regulation. When the Biden administration appealed Judge Reed O'Connor's ruling in the Mock versus Garland case, they were trying to save the ATF's pistol brace rule from complete collapse. That appeal was moving through the Fifth Circuit, a key federal court that covers Texas, Louisiana, and Mississippi, and everyone was waiting to see how it would play out. But now that appeal is gone. The new Trump Department of Justice has officially dropped the case, agreeing with the plaintiffs and the lower court that the ATF's pistol brace rule was invalid from the start. That decision means Judge O'Connor's ruling, which completely vacated the rule nationwide, is now final and in effect. Let's be clear about what that actually means. The nationwide vacatur isn't just a temporary block or an injunction. It's a full nullification. In legal terms, that rule no longer exists. It's as if the ATF never created it. For millions of gun owners, that's a massive relief. It means no one is currently required to register, modify, or destroy their brace pistols under this specific rule. It also means the ATF cannot enforce any penalties based on it, at least not until a future administration tries to write an entirely new rule from scratch. Now, the reason this is such a big deal goes beyond the braces themselves. This was one of the most aggressive examples of regulatory overreach we've seen from a federal agency in recent years. By dropping the appeal, the Trump DOJ essentially admitted that the ATF went too far and that the original court was right to strike it down. Judge O'Connor's opinion laid out why. He said the ATF's final rule was not a logical outgrowth of what it had initially proposed during the rulemaking process. That means the agency blindsided the public. It started with one proposal, but the final version was something completely different. That violates the Administrative Procedure Act, which exists to prevent exactly this kind of surprise regulation. So with the appeal withdrawn, that analysis stands unchallenged. The court's ruling isn't being reviewed, reversed, or limited. It's now part of the official record. But here's the interesting part. This single decision didn't just end the Mock case. It started a chain reaction across multiple other lawsuits challenging the same rule. And one by one, those cases are beginning to fall in line with the same outcome. After the Trump DOJ dropped the appeal in the Mock case, it didn't take long for the effects to spread. That single move immediately changed the tone of every other lawsuit tied to the pistol brace rule. The first major ripple came from the SB Tactical case, another big challenge that had the support of 25 states and multiple gun rights organizations. For months, that case was moving forward in a different circuit, but once the Mock decision became final, the writing was on the wall. The ATF agreed to settle. As part of that settlement, the agency acknowledged that it would no longer enforce the pistol brace rule and that the rule should be vacated in full. That's a huge admission coming directly from the ATF itself, essentially confirming what gun owners and attorneys had been saying all along, that the rule wasn't just overreaching, it was legally indefensible. But that wasn't the only case impacted. There were also other ongoing challenges from groups like Gun Owners of America, GOA, the Second Amendment Foundation, SAF, and several individual plaintiffs, all in different federal circuits. Each of those lawsuits had been paused or delayed while courts waited to see what would happen in mock. And now that the mock appeal has been dropped, those cases are beginning to line up for resolution too. It's a domino effect. Once the federal government concedes in one major circuit that the rule is vacated, it becomes incredibly difficult, almost impossible, to argue the opposite position somewhere else. So rather than fighting the same losing battle in multiple courts, the DOJ and ATF are now taking the path of least resistance, settling or dismissing the remaining cases. One of the most notable of those is the ATF Pistol Brace Challenge. The parties in that case had already agreed to pause proceedings so they could explore a potential settlement, one that likely would have mirrored what just happened in mock and frack. But right as that was moving toward resolution, something else happened that slowed everything down. And that brings us to the next major twist in this story: the government shutdown and how the ATF is using it to delay these final settlements. Just as the dust was starting to settle, the government shutdown threw a wrench into the process. The ATF Pistol Brace Challenge, one of the few remaining cases still active, was on the verge of being resolved. Both sides were reportedly discussing a settlement that would have likely followed the same outcome as the mock and frack cases. But now, the ATF and the Department of Justice have filed notices asking the court to pause the case entirely, citing the ongoing government shutdown as the reason. Here's what that means. During a shutdown, most federal employees, including DOJ attorneys, are legally prohibited from working unless it involves something that's an emergency or critical to protecting life or property. So the government's position right now is that they can't continue negotiating or filing legal documents until Congress restores funding. In their recent filing, the DOJ stated that, quote, absent an appropriation, Department of Justice attorneys and employees of the defendants are prohibited from working even on a voluntary basis, except in very limited circumstances. In other words, they're saying their hands are tied. No work can move forward until the government officially reopens. Now, on paper, that might sound like a reasonable excuse, but a lot of people see it for what it really is: another delay tactic. Because at this stage, the outcome is obvious. The ATF has already settled or conceded in multiple other cases involving the same rule. They know they're going to lose this one too. It's just a matter of time. So rather than finalize the settlement right now, they're using the shutdown to buy more time. They've asked the court to extend the reporting deadlines for as long as the shutdown continues, effectively freezing the case in place. This means the ATF case, which could have been resolved within weeks, might now sit idle until funding is restored. But make no mistake, once that happens, the case is expected to end the same way as the others, with the brace rule officially vacated and unenforceable nationwide. The shutdown isn't changing the result, it's just slowing down the inevitable. Now that the ATF's pistol brace rule has been struck down and the appeals are being dropped or settled, it's easy to think the fight is over. And for now, it's a huge win. No question about it. The rule is vacated nationwide. Gun owners aren't facing prosecution for owning brace pistols, and the ATF can't enforce this regulation in any capacity. But here's where things get interesting and a little complicated, because while this is a major victory, it's not necessarily a permanent one. When the Trump DOJ decided to settle and drop the appeals, they essentially chose the fastest path to ending the rule right now. But by doing that, they also gave up the opportunity to get a final, binding appellate decision that would set a long-term precedent across the country. Here's why that matters. The current victory in Mock versus Garland came from a district court, not a court of appeals or the Supreme Court. That means the ruling, while powerful, only applies as direct precedent within that jurisdiction. In other districts, it's considered persuasive, not binding. So if a future anti-gun administration takes office and tries to reimpose a similar pistol brace rule, they could attempt to rewrite it with slightly different wording and argue that it's new. Since there's no appellate or Supreme Court ruling on the books, they'd technically be free to try again, and the fight would start all over. In other words, gun owners have won the battle, but the larger war over administrative overreach isn't finished. This win stops the ATF's current attempt, but it doesn't completely close the door on what a future administration could attempt under the same playbook. That's why it's so important to pay attention not just to who's in the White House, but who's shaping federal agencies like the ATF and DOJ. Because while courts can correct overreach, it's the administration's stance that determines how often that overreach even happens in the first place. Still, this victory is enormous in the immediate sense. The nationwide vacatur remains in effect, the rule is unenforceable, and for the first time in years, gun owners have a real, measurable win against a federal firearms regulation. It's a reminder that these cases do matter, that pushing back through the courts works, and that sometimes a system still recognizes limits to bureaucratic power. Whenever a big ruling like this happens, confusion spreads fast, and the pistol brace decision is no different. Social media, forums, and even some gun shops are already filled with half-true claims about what this actually means. So let's clear up some of the biggest misconceptions right now. Myth number one, the pistol brace rule is gone forever. Not exactly. The current rule, the one written by the Biden-era ATF, has been vacated nationwide. That means this specific version of the rule is gone and unenforceable. But that doesn't mean a future administration can't try to bring it back in another form. If a future ATF rewrites the rule with slightly different language or justification, they could try to push it again. Whether they'd succeed or not would depend on how that new rule is structured and how the courts react the next time around. So yes, the current rule is dead, but forever is a strong word when you're dealing with government agencies and shifting administrations. Myth number 2, now you can build or modify any pistol however you want. No, that's not true either. This ruling only affects the pistol brace rule itself. It doesn't change the National Firearms Act, and it doesn't legalize short-barreled rifles that don't meet existing standards. You still have to comply with all NFA regulations, meaning barrel lengths, configurations, and definitions of rifles and pistols still apply. The only thing that's off the table right now is the ATF's attempt to automatically classify all brace pistols as SBRS. So don't go making assumptions or modifications thinking this opened the floodgates. It didn't. It just stopped the ATF from enforcing this one overreach. Myth number 3, you can ignore everything the ATF says now. That's a dangerous mindset. This ruling doesn't eliminate the ATF's authority entirely. It just stops them from enforcing this particular rule. They still have power under existing laws, and they'll still try to interpret those laws in ways that expand their reach. That's why staying informed is critical, because while this was a big win, it doesn't mean the ATF won't try something else next year, next month, or even next week. Clearing up these myths is crucial because misinformation can easily land well-meaning gun owners in serious legal trouble. The victory here is real, but it only protects you if you understand exactly what it does and what it doesn't actually do. So here's where everything stands. The ATF's pistol brace rule, the regulation that reclassified millions of legally owned firearms overnight, has been vacated nationwide. The Trump DOJ has officially dropped its appeal in the Mock v. Garland case, effectively letting the lower court's full block stand. Other major cases, like Frack v. Garland, have already been settled, with the ATF agreeing that it will no longer enforce the rule. And while the SAF case is being delayed because of the government shutdown, the outcome there is practically inevitable. The same result we've already seen in every other challenge. Right now, the pistol brace rule is dead in the water. The ATF can't enforce it. Gun owners don't have to register, modify, or destroy their brace pistols under this rule. That's not rumor. That's legal reality. But here's the bigger picture. This win, while massive, isn't the end of the story, because dropping the appeals also means we don't yet have a binding appellate precedent protecting this victory long term. If another anti-gun administration takes power, they could rewrite and reissue a similar rule, forcing gun owners to fight the same battle all over again. So this isn't the time to relax. It's the time to stay alert, stay informed, and keep pushing for clear judicial limits on what federal agencies like the ATF can and can't do. Because if history has shown us anything, it's that the fight for the Second Amendment never really ends. It just moves from one battlefield to the next. If you made it this far, you're exactly the kind of person this channel is for. Informed, responsible, and paying attention to what actually affects your rights. So do me one favor. Make sure you're subscribed and that your notifications are turned on. YouTube doesn't always send these videos out, but when the next legal decision drops, and it will, you'll want to hear it first. And let me know in the comments, do you think settling these cases was the right move, or should they have pushed for a permanent appellate victory? Your opinion matters more than you think. It helps shape how this conversation moves forward. As always, thank you for watching, thank you for supporting, and never forget, this nation was built by armed citizens, and it'll be preserved by informed ones.